Thank you for attending this tutorial. So this is not in respect of one specific chapter, but it's just a revision tutorial because we have covered all 8 chapters in the previous tutorial. So this is just a brief rehash of chapters 1 to 8. I'm also going to be incorporating some of the key areas that Prof mentioned in the lecture of yesterday. Then I'll just do one example question just so you can see ideally how to answer your long problem type questions. So that's today's tutorial. Okay, as usual with our reminders at the beginning of the tutorials, diagram on page 6 of tutorial letter 102, colleagues. Cannot emphasize it enough. I'm sure all of you have heard even from Prof during the lecture yesterday that is a nice summary. She even refers to cases in that diagram. So that is a very helpful diagram to just assist you in your preparations, assist you to understand what the module is about, just from a holistic high-level perspective. Once again, this is a tutorial. It does not substitute your classes, which are normally held on Tuesdays from 2 until 4. Yesterday, because of the issues with last week's lecture, you had a full day tutorial, full day lecture yesterday with Prof. But yeah, usually it was from 2 until 4. And then during yesterday's lecture, for those of you that attended, you'll know that Prof has indicated that there will be an additional full day lecture on the 28th of September, which is Saturday from 11 until 5. And she has added this class on because due to how the class or the lecture was conducted yesterday, there were a lot of questions coming through and she didn't manage to get through all of the content. So she has indicated that there will be that class on Saturday. So please do ensure that you do attend so that you can just have further insight on the content of the module. I'm sure she'll refer to the exam again because there were a lot of questions coming up about the exam, the structure and all of that. So please make every effort to attend that additional lecture on Saturday from 11 until 5. And then just to confirm, colleagues, this is the last tutorial. We've had 8. This is the 8th and the last one. So no tutorials next week or the week thereafter. This is the last one. That's why we are doing revision. Once again, tutorials are recorded and links will be provided by the tutorial officer, being Mr. Godfrey Mpafudi. A lot of you have been sharing your email addresses for him to send you the links and also the lecture slides. So yeah, he will send those through to you. He can only send it to an official UNISA email address in accordance with the policies of UNISA. And then, colleagues, this is only going to be a 1-hour session purely because it's just revision. So I would request that we reserve questions for the end just so that we can get through the content because we're going through all 8 chapters, so it is quite a bit. So if we can just keep questions for the end, note your question. If you do have a question from one of the slides, just note it down and then at the end we can address that just so that we can get through everything, seeing as this is the last tutorial. Okay. So first up, colleagues, the exam. Exam details. It's going to be on Monday, the 14th of October, 2024. It is a 4-hour paper. If I did hear properly, maybe some of you can correct me if I misunderstood, but I think Prof did say there would be an additional 30 minutes apart from that 4 hours, making the total time for the exam 4.5 hours. I think 4 hours was the initial time, and then she talked about an additional 30 minutes that would be allocated just to give you enough time to submit. And it's a closed book, meaning you won't have notes with you, you won't have your textbook, your constitution or anything like that. So you do have to study, ensure that you know your sections of the constitution, ensure that you know your relevant case law. She did also indicate that the Invigilator app will be used, so just be aware of that. And then, colleagues, what she mentioned was that at this stage, she has prepared the paper, a draft of it anyway, which is being circulated for approval. And in terms of that, there are going to be 4 questions. This is not final. It may be subject to change. So don't take this as the final indication of what is going to be in the paper. But she did state that at this stage, there's 4 questions, and it's long problem type questions. She stated that marks range from 18 to 38 marks per question. So that just gives you a clue of the type of studying you need to do and able to substantiate. And then I think one of your colleagues did request that she should consider putting in multiple choice questions, which she said she would consider if it is possible. So that might be something that might come up. But at this stage, as it stands, it's 4 questions, longer type questions, problem type questions, which you will have to answer with supporting sections from the Constitution as well as your case law. So at this stage, that is what we know. Okay, and then study points, colleagues. Cannot emphasize enough. Prof did also emphasize it. Please, please, please study all of the chapters. Please study all of the chapters. Don't leave any of the chapters out. Especially if there's a chance that the multiple choice will be incorporated, then that essentially means she can ask questions from literally any chapter. So you do want to ensure that you can get your marks where you can. So please, it's important to study all the chapters. And then Prof also specifically indicated that the content in for chapters 6 to 8, which is in tutorial letter 102, is not sufficient for exam purposes. So you will need to consult your textbook. What she means by that is that she's just basically done very high level summary of those chapters. So please, please, please do ensure that you consult your textbook just so that you can get an elaboration, a bigger picture of those specific chapters. Very important. That's what she mentioned. Make sure you memorize the sections of the Constitution and the names of the cases that you want to rely on, especially with the problem type questions. You won't be able to substantiate if you do not know your sections of the Constitution and if you do not know the names of the cases. So very important to know that, colleagues. And then when referring to cases, Prof did say that you do not need to give the full citation of the case, meaning you don't need to give, for example, the name of the journal, the page number, the volume number, and all of that. She said it would suffice to just give the names of the parties and then the year, because she says, for example, with your EFF cases, there's EFF cases where it's the same parties but it's for different years. So she just mentioned that you should at least refer to the year so that she can know exactly which case you are talking about. So, for example, Democratic Alliance versus Minister of International Relations 2017, so that you can know that you're referring to that specific case. And then she did also confirm that you can use recent case law, which is not mentioned in tutorial letter 102, as long as the case is well known and it is relevant to the question. So, yeah, as usual, just ensuring that it is constitutional principles that you are referring to. You can use any recent cases. Just make sure that they are well known and that you are applying it appropriately. And then exam question papers. I think one of the colleagues asked about past exam papers. I think you are able to get access to that, but Prof did mention that she cannot ask the same question, so she can't repeat questions. So the danger with just cramming or just studying past papers is that maybe those questions won't come up, and then you'll find that you haven't studied enough to actually address the questions in the current exam. So just bear in mind that questions cannot be repeated. You can use the past papers maybe just for practice purposes, but don't just cram the papers and think that you're going to pass because you can't repeat questions. And then, as always, when applying case law, colleagues, remember to use the relevant constitutional law principles in the judgment. As we always say, your constitutional court cases, 90% of the time, they're dealing with more than just constitutional principles. You'll find they're dealing with labor law, they're dealing with criminal law, they're dealing with other aspects of the law. But what Prof wants to see is that you're actually applying the constitutional principles of that case. So just ensure that you are doing that. And for example, you're not applying the Bill of Rights, as she always makes that example of S versus Makwanyane, the right to life. That's not what she's trying to test here. She's testing the constitutional law principles. And then if you have gone through your tutorial letter 102, you will note that there are test your knowledge questions at the end. So that would be good just for practice. She also puts like brief answers there. She doesn't elaborate, but she gives you sort of guidelines on what you would expect to see with those types of questions. So yeah, just have a look if you do have time to go through those questions and answers to see what Prof would expect. And then, so some of the important points that were mentioned, colleagues, I may miss some of what was mentioned because I did join the lecture late. So this won't be everything, but if I have missed out on something, please do mention it at the end, or please also let your colleagues know, whether in the WhatsApp group or the Telegram group, while you're doing your exam preparation. If things have been missed here that would be beneficial to your colleagues, please just share that information. I won't have 100% everything of what was mentioned because it was a lot. It was like a 4 or 5 hour session, so I won't have everything. So some of the areas, colleagues, that she emphasized on repeatedly, and I'm not saying you should only study these, but you should know these because Prof was mentioning them quite a lot. So I'm assuming they are important for the exam, or at least the longer type questions. She mentioned the separation of powers. This was the most emphasized part of the work that she talked about. She mentioned it a number of times. So please know your separation of powers. And while studying separation of powers, also please remember the counter-majoritarian dilemma, which you can use as part of your answer to substantiate. Maybe she will ask on it, maybe she won't, but just know that aspect as well so that you can just add as much to your answer as possible. She mentioned cooperative government. She also mentioned that people do confuse separation of powers with cooperative government. So I don't know if that means she's going to maybe test you guys in that way to see if you can differentiate between the two. But yeah, just know your cooperative government, which is basically your multi-sphere government and everything relating to that. She talked about participatory democracy. So please also make sure you know that, and specifically public participation in the enactment of laws. So how the public can actually get involved, and the requirement actually that public must be involved in the enactment of laws, and that the legislature must actually provide for that. She mentioned that. She also mentioned the rule of law. Frequently. She mentioned the public protector and binding nature of the findings of the public protector. I don't know if that is because she asked about the public protector in previous exam papers, but she had referenced that 1 or 2 times. So I don't know if that means it will be in the exam, but I just thought I should include it anyway. But yeah, the most emphasized thing out of all these things was the separation of powers. So make sure that you know that as well as you possibly can. Once again, diagram on page 6 of your tutorial letter goes without saying. Please know that, colleagues, it will just help you because it even refers to cases that you can use for those specific topics. And then some of the cases that were mentioned, again, a caution, please do not only study these, but at least know them. You need to know as many cases as you possibly can so that you can be able to answer your longer type questions. She mentioned the cases on page 33 of tutorial letter 102, and these are actually all in relation to separation of powers. So I think, again, a hint that separation of powers will be very important. Your EFF cases, guys, she mentioned these a number of times. The DA versus Minister of International Relations, she mentioned that as well. So please ensure that you know those cases, just brief facts. What was the judgment? And remember, we're looking at the constitutional law principles in these cases. And then I've just cited some of the other cases, Mazibuko versus Sisulu, which was in relation to the raising of a motion of no confidence, or was it impeachment? One of those two concepts, though, about the removal of the president. So please have a look at that. Have a look at Corruption Watch as well. The Menzi Simelane case, City of Tshwane versus AfriForum, and then the cases cited in the diagram on page 6 as well, because there she actually shows you where the case would actually apply. So please just have a look at that as well. And then, yeah, so that's from the important points, that's what I had picked up. But again, if I have missed anything, or if you have additional information, please just mention it at the end. Or please also share that information with your colleagues so that you can all know basically what you need to focus on. Okay, and now for revision, colleagues. So this is just a high level revision to refresh your memory. So I'm not going in depth. I'm not going to go in depth. It's purely just for purposes of refreshing your memory on the content of the chapters. Opelong, I see your hand is up.
Hi, ma'am. May you kindly just go back to the previous slide? I just want to take a quick picture. That's it.
Okay, sure. You'll let me know when you've taken the picture, right?
Yes, I'm done. Thank
Okay,
you.
sure. Okay, colleagues, so just some notes on this high-level revision that I'm doing. It's literally for purposes of just refreshing your memory, guys. I'm not going in depth. I'm not regurgitating what was done in the previous tutorial sessions. Otherwise, that will take up too much time. So it's really high level just to refresh your memories on what each chapter was about. Please, 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 I beg, do not rely only on these revision notes. You can just use it maybe at the end of your study session when you are trying to test yourself or see if you do understand the work. Please, please, please study content in chapters 1 to 8. Please refer to the extended explanations in your textbook to ensure you understand the concepts, because you will have noted even in tutorial letter 102 the fact that some of the things are not really elaborated on, especially in those chapters that Prof said you must actually go and read the textbook. So please just ensure that you do understand the concepts, because sometimes she'll just use a keyword and you won't necessarily know what she's talking about unless you go to the textbook and read up some more. So please ensure that you do that. And then please ensure that you understand the constitutional concepts of the cases in the various chapters. Cannot stress that enough, because if you don't understand the concepts, then you won't be able to apply. Okay, colleagues, then without further ado, we start at chapter 1. And this was the South African constitutional law in context. What is a constitution, colleagues? A constitution is a founding document upon which the authority of a state is premised, and it establishes the organs or structures of the state or government. It authorizes, regulates, and limits the exercise of power by branches, institutions, and persons. And it also provides ground rules for the effective functioning of the state. So that is the constitution. What is constitutional law specifically? So it's the law that regulates the relationship between the three principal organs of state, namely the legislature, the executive, and the judiciary. And for South Africa, this relationship is regulated within three spheres of government as well, namely the national, provincial, and local spheres. And what we have in South Africa is a transformative constitution, colleagues, meaning it is aimed at full legal, political, and socio-economic transformation. So it's not just a document with a bunch of rules. It is actually aimed at changing society. And South Africa's constitution specifically is informed by various historical stages. I'm not going to go into that history, but if you go to the slides for chapter 1, you'll see I did a brief summary of that, those historical stages where it talks about the union state, the previous constitutions that were enacted and all of that. So you'll find that in I think it was the first tutorial. So yeah, it's informed by those various historical stages and particularly aimed at addressing the apartheid injustices. And then the characteristics of the Constitution, colleagues. In terms of citation, it does not have an act number because of its status as the supreme law of the land. That is why it does not have a number like any other act. Because it's supreme, it's the most important law, so they didn't want to equate it with other laws by giving it a number, but also it wasn't passed like any other ordinary legislation would be passed, so they did not give it a number for those reasons. And then constitutional supremacy, which eradicates parliamentary sovereignty. And once again, constitutional supremacy just means that the Constitution is the supreme law of the land. Any conduct or laws that are inconsistent with the Constitution will be declared invalid, or they are invalid rather. And then it's also based on a sovereign state founded on human dignity, equality, freedom, non-racialism, non-sexism, universal suffrage protected by a Bill of Rights. The rule of law, it's a democratic multi-party system with free and fair elections regularly. We have an independent judiciary. We've got the separation of powers. It is transformative, as I mentioned above. It is post-liberal, meaning it is identical to constitutions of liberal democracies, such as Germany, for example. And then the unique attributes of constitution, colleagues. It is social and it encapsulates a social and substantive conception of equality. That means that rights can be exercised meaningfully. It's affirmative. There are positive duties on the state. It is horizontal, meaning that it does not only apply between the state and you and I as citizens, but it also applies between citizens, meaning I have to respect your rights as an individual, you have to respect my rights as an individual. There's participatory governance, meaning that there's participation by citizens in decision-making in all spheres of government. And then it's also based on multiculturalism, being Ubuntu and the right to be different. So those are just some of the unique attributes of the South African Constitution specifically. Okay, colleagues, and then chapter 2 covered the basic concepts of constitutional law. And for purposes of this discussion, 4 concepts were identified, being constitutionalism, separation of powers, the rule of law, and democracy. You cannot understand South African constitutional law if you do not understand these concepts, colleagues. So please make sure that you do understand each one of these concepts, especially how they are outlined and explained in the textbook. So with constitutionalism, colleagues, it is defined as the idea of a political community in which elected politicians, government officials, and judicial officers act under the authority of a written constitution, because legitimacy and power is derived from the constitution itself, and the constitution places limitations on the exercise of these powers. So it basically is the idea that there'll be a written constitution that will actually guide the use of power by government. The precise manner in which a constitution is structured and interpreted is based on the political and social history of that community. Thus, constitutional systems are based on explicit norms and values, and that was indicated in the case of S versus Makonyane at paragraph 262. And then, colleagues, we've got 2 different types of constitutionalism or approaches or perspectives on constitutionalism. The first being descriptive constitutionalism. And with this, what we mean is that it basically just provides a factual description of institutions, procedures, and structures that make up a constitutional system. It focuses on explaining the distribution of power between the branches of government. It does not concern itself on whether the state power is being used in contravention of democratic or human rights and norms. It does not make value judgments on whether the state adheres to its own constitutional limits. So it's basically just descriptive, as it says. It just describes the division of power between the various branches of government. It does not look at norms or standards or anything like that. And this describes the pre-democratic dispensation in South Africa, where parliamentary sovereignty was in place. The courts could literally just apply the law as it was. They didn't make value judgments or anything like that. It was just strictly the letter of the law. And then we've got what we call prescriptive constitutionalism, colleagues, and this seeks to define in general terms the manner in which state power is allocated and exercised. But it goes further than that, colleagues. It actually establishes norms and principles that define a constitutional government. It demands that constitutional systems should adhere to norms and principles such as the separation of powers, the rule of law, democratic self-government, the protection of human rights, and the existence of an independent judiciary. So a more value-based approach here, colleagues, where we look at more than just the division of power, but we make value judgments. There are norms, there are standards, there are principles that have to be adhered to. And it represents South Africa in its current democratic dispensation. And then characteristics of a constitutional government. This is one that has norms and values. It has constitutional supremacy at the forefront. It's got a separation of powers, it's got the rule of law, it's got democratic self-government, protection of human rights, an independent judiciary with the power to review law or conduct, free, fair, and regular elections, institutions established to uphold and protect the Constitution, as well as the devolution of power. Okay, and then the separation of powers, colleagues, just as a high-level concept. It is a doctrine which entails the institutional division of public power between the three branches of government, namely the legislature, executive, and judiciary, in order to limit power. And its purpose is to create a society in which the abuse of power by government is curtailed and public power is exercised appropriately. It ensures predictability and transparency, and that power is not concentrated in one branch, person, or office. So it's basically to avoid abuse of powers, and it's an institutional division between those three branches of government. So colleagues, note that there is no provision of the Constitution which makes reference to the separation of powers. So if you go to your Constitution, you're not going to find a specific section that actually says, here is the separation of powers. Government is divided into this and this and this and this. No, you're not going to find that. But we see from the arrangement of the Constitution that it actually does envisage the separation of powers when we look at the various sections and how the Constitution is actually arranged, that it does consider the separation of powers. You can look at Glenister in this regard, the case of Glenister. Okay, and then the rule of law. So the rule of law, colleagues, there's a lot of uncertainty about what the rule of law actually is. What we do know is that it's actually an independent and enforceable principle, but the definition is a bit elusive. We do have different approaches. The first is the one by Albert Dicey in 1885, where he stated that since the law is supreme, public power can only be exercised in terms of authority conferred by law, and no one may exercise public power arbitrarily. He went on to also state that everyone is equal before the law. The law must be applied equally to all persons, irrespective of their status, and all must be subject to the jurisdiction of the ordinary courts. The ordinary courts are responsible for enforcing laws in a manner that protects the basic rights of all, so that these laws function as a constitution. And then we also got a reformulation of the concept by Anthony Matthews in 1964, and he said that in a decent society, the idea that the state should wield arbitrary power over the individual is unthinkable. All persons, including government officials, are equally responsible to the law. Effective judicial remedies afford the individual greater protection than constitutional declarations. So what we can draw from this is that the rule of law is premised on the following. The government or state must act in terms of pre-announced, clear, accessible, and general rules that are not vague and uncertain. Rules that are created must be informed, and disputes pertaining to such rules must be adjudicated by independent and impartial courts. No rights of people may be determined, deprived, or limited through overly broad and arbitrary discretionary powers. And then no one is above the law. So all persons, including the state, must act in terms of powers granted by laws and comply with laws. Okay, then the last concept, colleagues, in terms of chapter 2 is democracy. And once again, democracy is a very elusive concept. There's no fixed way of defining it, but what we do know is that it is an independent and enforceable principle. It is based on the idea that the will of the people should prevail and people should have a say in how they are governed. And the foundational reason for democracy is to enable members of a political community to act together, taking decisions collectively in matters that affect them. So as we can see, democracy is all about participation, how you and I should exercise our rights to have a say in the laws that govern us. That is what democracy is about, us having our say. And then in terms of the Constitution, colleagues, you can look at Section 1D and Section 19 in relation to democracy. And there are 5 different types of democracy, colleagues. There's not just one, there are 5. So make sure you understand that as well. We've got direct democracy, which means that the people have a direct say and direct participation on the part of citizenry. We've got representative democracy, which envisages political parties assuming preeminent roles in governance. And in South Africa, particularly, every 5 years, the public elect representatives to act on their behalf, and we subscribe to the closed list proportional representation system in this regard. We've also got multi-party democracy, so we don't just have a single party. There's actually no limitation on political participation. At a political party level, anyone can form a political party, and parties that meet the threshold are then represented in parliament. And then participatory democracy, colleagues, one of the concepts that Prof did actually mention is important. This means that whenever any decisions are made regarding the amendment or introduction of new legislation, the people must be given an opportunity to meaningfully participate in the process, failing which the legislation would be declared invalid for failure to comply with the procedural aspects of the Constitution. Very important. So what we know about participatory democracy is that it actually augments representative democracy, in that although there are representatives, the public should not be totally excluded from decision making. They should still have a say in the laws that are enacted, in everything that's happening in the legislature. So colleagues, in terms of sections of the Constitution on participatory democracy, you can have a look at Section 59, which actually places an obligation on the National Assembly to facilitate public involvement in the legislative and other processes of the National Assembly and its committees. And we've also got Section 72, which is actually a mirror of Section 59, but this one is in respect of the National Council of Provinces, and it states that it also places an obligation on the National Council of Provinces to facilitate public involvement in the legislative and other processes of the National Council of Provinces and its committees. You can look at the judgment or the case of Doctors for Life versus Speaker of the National Assembly, also City of Tshwane versus AfriForum in relation to public involvement in relation to those sections specifically. Then lastly, colleagues, we've got constitutional democracy. This just means that political decisions are made in terms of a constitution, and all law and conduct must be compatible with the constitution. If it is not, it must be declared invalid, as we know. Okay, moving on to chapter 3, colleagues, which is the separation of powers. NB, as I said in the beginning, this is one of the chapters that Prof has emphasized on now and again, so please do make sure that you understand it. The separation of powers, colleagues, as we mentioned in the previous slide, it is a doctrine which entails the institutional division of public power between the three branches of government, namely the legislature, executive, and judiciary, to limit power. And its purpose is to create a society in which abuse of power by government is curtailed and public power is exercised appropriately. It ensures predictability, transparency, and that power is not concentrated in one branch, person, or office. It upholds and safeguards important democratic values and norms, namely accountability, responsiveness, and openness. Once again, there's no specific provision in the Constitution that talks about the separation of powers, but we do gauge from the arrangement of the Constitution that we do actually subscribe to the separation of powers through the different branches. And then the four pillars of the separation of powers, colleagues, we've got trias politica, which is the actual institutional division. This just means that government must be divided into the three branches, namely the legislative branch, the executive branch, and the judicial branch. We need to have a separation of functions, meaning that each branch of government is confirmed with different areas of responsibility and authority. We've got a separation of personnel, meaning each branch must be assigned to its specific persons who are responsible for the performance of the functions of that branch. Please do note, colleagues, that this is not always the case, this separation of personnel. Even though it is ideal, we do get overlaps at times. So it's not always possible to separate personnel between the various branches. Sometimes it does overlap. And then we've got checks and balances, where one branch can hold another branch accountable to check the exercise of power by that branch. And then this is just an overview, colleagues, of the branches of government, where we've got the legislature. Its functions are to debate, draft, and amend and repeal laws, and also hold the executive accountable. The National Assembly is composed of 400 representatives, known as MPs, who represent all political parties that reach the required threshold of votes in proportion to the overall number of seats. At the first sitting of Parliament, the president is elected. Once the president is elected, he is no longer part of Parliament, but he becomes an MP. And then any MP can introduce legislation to be debated and passed. And then we've got the executive, colleagues. Its function is to implement the legislation passed by the legislature. It makes policies and implements and administers the law, and it also makes crucial appointments. It comprises the president as the head of the executive, as well as the head of the executive, as well as the head of state. And then we've also got the deputy president and the cabinet ministers. The president has the power to appoint and dismiss cabinet. However, the president must remain accountable, responsive, and open, and act under the principle of legality and act rationally. Otherwise, the exercise of public power may be set aside by the Constitutional Court. And the executive is accountable to Parliament and must report to it regularly. And Parliament may remove the executive, as we will see later. And then lastly, we've got the judiciary. Its function is to interpret and adjudicate legal disputes. It's also got the very important function, colleagues, of declaring laws invalid, those laws which contravene the Constitution. It comprises magistrates, judges, and justices in various courts. And the judiciary may not intervene in the legislative process until it is completed, unless no other remedies are available, colleagues, and harm would be caused. The harm to be caused would be material and irreversible. That is when it would be entitled to intervene. We've got that Oriani Ambrosini case where the court declared rules of the National Assembly unconstitutional, as they did not allow ordinary MPs to introduce legislation. And then judges are appointed by the president after extensive interviews with the Judicial Services Commission. Judicial officers must at all times remain independent and impartial, and judges are guaranteed security of tenure, and salaries may not be reduced. Judges also may be removed through investigation by the Judicial Services Commission. So we see a big role for the Judicial Services Commission in the appointment and removal of judges, their colleagues. Okay, separation of powers continued. Colleagues, we've got checks and balances, which you noted was one of the 4 pillars of the separation of powers. And what is meant by checks and balances is just that restraints are exercised by one branch of government over another to ensure that the branches of government do not usurp power one from another. This necessitates the unavoidable intrusion of one branch on the terrain of another. It's a prominent feature of South Africa's democratic dispensation, maintains an equilibrium in the exercise of power. In South Africa, we mainly see checks and balances when the judiciary is empowered to check whether the other branches comply with law and exercise their authority in conformity with the constitution. So that is where we actually see these checks and balances in practice, colleagues. The counter-majoritarian dilemma that I referred to as well at the beginning of the tutorial, colleagues, this just refers to the dilemma that the idea of judges overturning decisions of the legislature through judicial review undermines democracy by thwarting the will of the majority through a subjective reading of abstract constitutional principles. So what they're basically saying here, colleagues, is when Parliament enacts laws, right? The fact that those laws can actually be taken to court and be declared invalid by the court, that would, on the face of it, or prima facie, it would appear as though the powers or the authority of Parliament or the legislature are actually being undermined. So there has been a lot of debate about this, whether that power of courts to declare laws invalid, whether that does intrude too much on the powers of the legislature. And the answer, well, you can argue it either way, but what we do see in the South African Constitution, colleagues, is that there's a safeguard in Section 172, because any person or organ of state with a sufficient interest may appeal or apply directly to the Constitutional Court to confirm or vary any order of constitutional invalidity by a court in terms of the subsection, meaning that if a lower court, for example, the SCA or a high court declares a law invalid, it still has to be confirmed by the Constitutional Court. So that is a safeguard that is put in place. But another argument as to why the counter-majoritarian dilemma is actually, it's not an infringement on the authority of the legislature, is the fact that courts can only declare invalidity. They do not rewrite the law or legislation in particular, sorry. The courts can only declare the invalidity, then they have to refer the law back to Parliament to amend. So they cannot rewrite legislation, so they are not necessarily infringing on the separation of powers, because it still has to go back to Parliament, who will then rewrite the law. So that's just some discussion on the counter-majoritarian dilemma. We also see that the rule of law provides a safeguard, because all branches of government are subject to the law. It's not just the executive and the legislature. Even the courts themselves are still bound by the Constitution. And then these cases, colleagues, I also mentioned them at the beginning of the tutorial. These are some of the cases you can refer to when you are talking about the separation of powers. So just make sure that you are removing or you are studying the relevant concepts pertaining to the separation of powers in these cases, so that you are able to apply to your answer in the exam. Okay, and then the national legislature, colleagues, this is the lawmaking body of government. Its functions include considering, passing and amending or rejecting legislation on any subject matter that falls within its jurisdictional areas of competence. It ensures that all executive organs of state in the national sphere of government are accountable to it. It maintains oversight of the exercise of national executive authority, including the implementation of legislation, and it maintains oversight of any organ of state. Excuse me. South Africa currently has a party proportional representation electoral system. So under this system of proportional representation, it is the parties that the electorate votes for, and parties which must be accountable to the electorate. So we vote for political parties, and then they are accountable to us as the electorate, because we've voted them into power and they represent us in Parliament. And then the South African Parliament, colleagues, it is bicameral, meaning it consists of two houses, the first being the National Assembly, which is the dominant house of Parliament with far-reaching powers, and the second house is the National Council of Provinces. This one has a less defined role in holding the executive to account and has no role in the appointment or removal of MPs. So, colleagues, I will emphasize this again. Please, please, please don't confuse the National Council of Provinces with a provincial legislature. The National Council of Provinces is right at the top. It forms part of the national legislature, whereas each province has its own provincial legislature. So please don't get confused and think that the National Council of Provinces is sitting at the provincial level. It is not. It is still at national level, and it just entitles participation of the provinces in parliamentary business. And then the National Assembly, colleagues, being the first house, it consists of 400 members. They are elected by their respective political parties in a national election. So the higher up on a political party's electoral list a person is ranked, the more likely it is that such person will be elected to the National Assembly. So what the parties do is they will prepare a list of names. And then, for example, if they prepare a list of 200 names, if they prepare a list of 400 names, basically for all the seats in Parliament, and they only win 50% of the vote, then it will be those first 200 people that will actually represent that party in Parliament, colleagues. And the functions of the National Assembly include the election and dismissal of the president, passing of legislation on any matter. It is a national forum for public consideration of issues, participation in public meetings of the National Assembly where they may ask questions of members of the cabinet, also known as question time. Scrutinize and hold all executive organs of state in the national sphere of government accountable to it, maintain oversight of the exercise of national executive authority, including the implementation of legislation and especially the authority to use state resources and the spending of public money. The National Assembly also plays a decisive role in various appointments, such as the commissioners of the Chapter 9 institutions. Then MPs or members of parliament have specific privileges. They've got the privilege of freedom of speech. This is in relation to parliament, colleagues. So it's not outside parliament, but it is in respect of things that are said in parliament. And then we've got freedom from civil or criminal proceedings, arrest, imprisonment, or damages. That's also in respect of parliamentary proceedings, not outside. And then the limitations of the National Assembly is that it must always act in an open and transparent manner, and it cannot make rules contrary to the constitutional requirement of openness. Members of the National Assembly, as well as cabinet members who appear before the National Assembly, enjoy certain privileges which cannot be curtailed by Parliament or anyone else. And then the National Assembly, colleagues, importantly, is required to facilitate public involvement in the legislative and other processes. Very important. And then we've got the National Council of Provinces. It comprises 90 members. These are elected through the provincial legislatures. The 90 members represent a single delegation from each of the 9 provinces, each consisting of 10 delegates. The 10 positions in a provincial delegation are allocated proportionally to the various parties represented in the provincial legislature in question in accordance with the relative strength of parties. For example, if the ANC received 60% of the seat in the legislature, then it would get 6 seats. Okay, then the 10 members of each provincial delegation are classified as either special or permanent delegates. 4 of them are special delegates and 6 are permanent delegates. And that is in respect of each provincial delegation, colleagues. And then the 4 special delegates are the Premier with 3 other delegates selected from the other members. And the functions of the National Council of Provinces includes representing the provinces to ensure that provincial interests are taken into account in the national sphere of government. So again, the confirmation that the NCOP does sit right at the top. And to participate in the national legislative process. It provides a national forum for public consideration of issues affecting the provinces. And then the limitations of the National Council of Provinces, similar to the National Assembly colleagues, it must act in an open and transparent manner, and it cannot make rules contrary to the constitutional requirement of openness. Members of the National Council of Provinces, as well as the cabinet members who appear before them, enjoy certain privileges which cannot be curtailed by Parliament or anyone else. And then, similar to the National Assembly colleagues, the National Council of Provinces is required to facilitate public involvement in their legislative and other processes. Okay, then in terms of passing legislation, colleagues, we have what we refer to as competence. So competence to pass or enact legislation. That just means that it is the ability of a specific sphere of government to actually pass laws. So if you go to Schedule 4, it's right at the end of your constitution, colleagues. It contains a list of areas over which national and provincial legislatures have concurrent competence to pass legislation. So it means that both of them can pass legislation in respect of those specific matters. And if there is a conflict, colleagues, between national and provincial, then national legislation would prevail in accordance with Section 146. So there's specific criteria in 146 that would have to be complied with if national legislation is to trump provincial legislation in the event of a conflict. So it's only in the event of a conflict that you would look at Section 146 to actually determine what those criteria are for national legislation to trump provincial legislation. And then Schedule 5, colleagues, contains a list of areas over which provincial legislatures have exclusive competence to pass legislation. And the national legislature may intervene to pass laws on Schedule 5 matters in accordance with Section 44(2), subsection 2. So once again, the matters in Schedule 5, those are exclusively for the provincial legislatures to enact, but the national legislature would actually be able to intervene and pass laws in respect of those matters if they comply or in accordance with the provisions in Section 44, subsection 2. And then we've got the tagging of bills. Bills must be classified or tagged into a category before introduction to Parliament to determine the procedure to be followed. And for that purpose, we've got a joint tagging mechanism, which is a group of people in Parliament comprising the Speaker, the Deputy, and Chairperson, and deputies and they make final rulings, colleagues, on the classification of bills. So what type of bill is it? The joint tagging mechanism would actually determine what type of bill this is and therefore what procedure it should follow in order to be passed. And then the types of bills, we've got bills amending the Constitution, we've got ordinary bills not affecting the provinces, we've got ordinary bills affecting the provinces, and then we've got money bills. And I've also just referred to the different sections where you can find information on these types of bills, colleagues. Please consider the practical procedure of how legislation is passed. And this is outlined on pages 66 to 68 of tutorial letter 102. It basically outlines how proposed legislation actually goes from just being an idea to going through all the stages until it is signed into law by the president and therefore enforceable. Colleagues, I do see that it is 7 o'clock, so we've run out of time. I am able to continue, but I would just like to confirm with Godfrey if we can continue firstly, and then also maybe to hear from you guys if you are able to continue, if you do have time to continue, or if we should reschedule to another day. Just want to see.
Ma'am Kasambara, I'm here. I think we
Yes.
can continue. I don't have a problem on my
Okay.
side. Yes.
Okay. All right.
Thank you.
Perfect.
Yes, please continue.
Okay. All right. Perfect, guys. I'll continue. Thanks. But anyone who does need to hop off, Godfrey is able to provide the link to the recording. So if you do need to go, colleagues, you can still access the recording for those purposes. Okay, moving on to participation by the public, colleagues. I've put stars on this once again because Prof did mention it in yesterday's lecture. She emphasized on the importance, so please make sure you do understand this in the relevant sections as well. And in this regard, colleagues, Parliament may not operate in secret, and it has a positive duty to actually provide for meaningful opportunities for public participation in lawmaking. The question is always whether the legislature acted reasonably in facilitating public involvement. So this is an objective test, colleagues, of finding out whether Parliament actually enabled public participation. So the first thing you'd look at is the nature and importance of the legislation and the intensity of its impact on the public. What is practically possible with reference to time and expense, which relate to the efficiency of the lawmaking process, but saving money and time cannot justify inadequate opportunities for public involvement. What Parliament deems appropriate public involvement given the legislation's content, importance, and urgency. So those are some of the factors that they would look at in terms of public involvement. And then participatory democracy, colleagues. So you can see that this concept of participatory democracy that we talked about under democracy is closely linked, or it nicely encompasses this point of the public actually being involved in the making of laws. And participatory democracy requires that the National Assembly and the National Council of Provinces must, so it's not even discretional, they must facilitate public involvement in the legislative and other processes of Parliament. So again, I'm not going to repeat these sections. I did refer to them when I was talking about participatory democracy, but these two sections just reiterate that the public does need to be involved in lawmaking. Strategies, colleagues. Some of the strategies that have been designed to guarantee public involvement in the legislative process include lobbying by organized groups in civil society to present well-reasoned arguments to targeted decision makers, which may include detailed written representations outlining the group's views on a particular issue. Members of the public can also raise issues at the constituency offices of the elected representatives, who then raise these issues in the legislature on their behalf. Petitions also allow individuals or groups to raise issues in a formal way without having to go to a particular member of the legislature. And the legislature does take note of these at times. It doesn't always sway them, but they do note petitions that have been raised on a specific matter. And then there are also public hearings, which are normally convened by standing committees. And these afford the public an opportunity to make a written or oral submission on any matter for which a public hearing has been convened. So these are the ways, colleagues, in which the public can actually be involved in the lawmaking processes. And then I've just listed some of the cases on public participation, which you can take note of. And then on the delegation of legislative authority, colleagues, Section 44, subsection 1 of the Constitution confirms that Parliament may assign its legislative authority, except the power to amend the Constitution, to any legislative body in another sphere of government, meaning at provincial level or at local government level. But power may also be assigned to Parliament may not delegate its plenary legislative power. And this is the original power to make legislation to an executive authority. As such, delegation will breach the separation of powers doctrine. So what they're talking about here, colleagues, is first, we need to understand that Parliament, which is right at the top, the national level, It can delegate lawmaking powers to other legislative bodies, being provincial legislatures or your municipal councils at local government level, but they can also delegate lawmaking powers to the executive. But this is only done in respect of subsidiary legislation, like your proclamations, your regulations, and things like that. They cannot delegate to the executive the power to make an original law, like a fresh act. They cannot do that, but they can ask the executive, a specific minister, for example, to make regulations on a specific matter just for practical purposes. Okay, so those are the delegation powers. And then chapter 5, colleagues, this was dealing with the national executive. The executive is responsible for the day-to-day running of a country and the implementation of law and policy. Its function is the coordination of functions of state departments, and they perform executive functions as well. It comprises the president, the deputy president, and cabinet of ministers. So it's usually made up only of members of the leading party. The majority party in the National Assembly. Up until now, we've seen something different with the government of national unity, where we've actually got different political parties. Just because ANC did not get an outright majority, now we are seeing actually that members of different parties, the DA, the EFF, all those parties are actually represented now in the executive for the first time in this democracy, since this democratic dispensation commenced. And then a bit on the president, colleagues. The president is elected by the National Assembly. So we do not elect the president directly like some other countries, but we elect him indirectly through the political parties. The president functions as the head of state as well as the head of the executive. The president's powers are limited. Please look at pages 72 to 73 of your tutorial letter for these limitations. The term of office, the president cannot serve more than 2 terms, colleagues. So that's a maximum of 10 years. That is the maximum time that the president can serve. And then removal, colleagues. The president can be removed in one of 2 ways. And I think sometimes you do get confused with these 2 concepts. But the first way is through impeachment, and the second way is through a motion of no confidence. So impeachment is regulated in section 89. They don't refer to the word impeachment. So if you go there and you're looking for the word impeachment and you don't see it, please don't get confused. We just refer to that mode of removal as impeachment. We just refer to that mode of removal as impeachment, but in essence, it is referring to the removal of the president for a serious violation of the constitution, or of any law, or if there has been serious misconduct or an inability to perform the functions of office. So that's when you would impeach the president. It's a very high threshold, very serious. And then the second way is a motion of no confidence. And this is in terms of section 102, subsection 2. And this can be for purely political reasons. So, for example, the National Assembly just doesn't support the president anymore. Then the president can actually be removed by a motion of no confidence. So it doesn't necessarily have to be wrongdoing on the part of the president, but if they just feel like he's not suitable anymore, then they can remove by a motion of no confidence. And then we've got the deputy president and cabinet, colleagues. The deputy president is appointed by the president from among the members of the National Assembly. Ministers are also appointed by the president, and all of them except 2 must be appointed from members of the National Assembly. An important note, the president and the 2 members who do not continue, it's only the president and the 2 members who do not continue to be part of the National Assembly. All the other ministers are actually still part of the National Assembly. At the same time, they are part of the executive. So there's an overlap there, colleagues. And then powers. The president assigns powers to the deputy president and the ministers as well in terms of section 91. The president usually does this, colleagues, by giving the ministers various portfolios that they must be responsible for, and we refer to them as departments. So that is how that is done. And then the deputy president must assist the president in the executions of the functions of government. That is provided for in section 91, subsection 5. And then the accountability of ministers, colleagues, they are accountable in different ways. They are accountable individually to the president and to the National Assembly for the administration of their portfolios. They are also collectively and individually accountable to Parliament for the exercise of their powers and performance of their functions. And they are collectively accountable for the performance of the functions of the national government and its policies. Excuse me. Then there's an executive ethics code which is published by the president, which members of the cabinet must comply with, and it includes provisions like ministers, for example, must declare their financial interests. They must not engage in other paid work. They must not mislead the president. They must not mislead the legislature. So there's an executive code there that must be complied with. And then the removal, colleagues of the deputy president or cabinet, they can either be removed by the president, and this decision is purely political, but the president will usually consult with the leading party before actually removing the deputy president or cabinet. And then they can also be removed by a motion of no confidence, and this is by the National Assembly, and this is provided for in section 102, subsection 1. Okay, and then moving on to the judiciary. The judiciary is the adjudicative branch of government. Its functions are to apply and interpret the law. It acts as a referee of the democratic process. It checks whether the legislature and the executive are acting within the boundaries set out by the Constitution and legislation. And the roles of the court in constitutional democracy. The courts are very important, colleagues. They are actually considered the bastion of the legal order. In a constitutional democracy with a supreme and enforceable constitution, an independent judiciary specifically is free to interpret and apply the law impartially and without consideration of the wishes of politicians, powerful business interests, or civil society groups. Checks and balances can only operate optimally if an independent and impartial judiciary is empowered to enforce the provisions of the Constitution. The judiciary checks whether the two political branches of government, being the legislature and the executive, act within the boundaries set out by the Constitution and by legislation. So what we can gauge from here, colleagues, I don't know if this is clear to you, but you should always remember that the judiciary is not elected like how the executive and the legislature are elected. That's why we refer to the executive and the legislature as being political. The judiciary is independent, and therefore they are appointed based on their skills, because they need to be independent and impartial, so it cannot be linked to any political appointment or anything like that. And then the court structure, colleagues, this is provided for in section 166 of the Constitution, where we've got the Constitutional Court, the Supreme Court of Appeal, and other appeal courts. There's two others, the Competition Appeal Court as well as the Labor Appeal Court. And then we've got high courts and other courts of the status of high courts, as well as magistrate courts. And then when we talk about jurisdiction, we talk about the power or competence of a court to hear, adjudicate on, and to determine or dispose of a legal dispute. And we always distinguish, for purposes of constitutional law, between constitutional and non-constitutional matters or issues. And when we talk about constitutional matters, we are talking about any issue involving the interpretation, protection, or enforcement of the Constitution, colleagues. So following the Constitutional 17th Amendment, which was in 2013, the Constitutional Court has become the highest court in all matters. So before that, it was only the highest court in constitutional matters. And then the Supreme Court of Appeal was the highest court in non-constitutional matters. But after this amendment, colleagues, the Constitutional Court is the highest court in all matters. But we need to note that the Constitutional Court cannot hear appeals based solely on factual disputes. So in cases where an appeal is lodged with the Constitutional Court, that does not deal with a constitutional matter, the Constitutional Court has a relatively wide discretion to decide whether it will hear the appeal or not. And as a general rule, the Constitutional Court is reluctant to grant direct access, as it would then have to decide legal and factual issues without the benefit or wisdom of one of the lower courts. And it has ruled that the court is placed at a grave disadvantage if it is required to deal with difficult questions of law, constitutional otherwise, virtually as a court of first instance. So the Constitutional Court basically does shy away from just hearing appeals left, right, and center if they just basically aimed at factual disputes, and if you're just appealing on that basis and there's no real constitutional element to it, you have to convince the court why it should actually hear those matters. But we do have matters, colleagues, which fall within the exclusive jurisdiction of the Constitutional Court. And what this means is that here the Constitutional Court is the court of first instance. You get direct access. You can go directly to the Constitutional Court if it is in respect of any of these matters. And we call them matters falling within the exclusive jurisdiction of the Constitutional Court. No other court can hear these types of matters except for the Constitutional Court. So a confirmation of an order of the Supreme Court of Appeal or the High Court, that legislation is unconstitutional and invalid. So yeah, as we said previously, the High Court and the Supreme Court can declare laws invalid. However, this is always subject to confirmation by the Constitutional Court, and only the Constitutional Court has that power to actually grant the confirmation after it has been declared by the lower courts. And then disputes between organs of state in the national, provincial, or provincial sphere concerning the constitutional status, powers or functions of any of those organs of state, deciding on the constitutionality of any parliamentary or provincial bill referred to it by the president or the relevant premier in terms of section 79 or 121 of the Constitution, when the president or the respective premier has reservations about the constitutionality of a bill, deciding on applications by members of the National Assembly or provincial legislatures to declare invalid all or parts of the Act of Parliament or the provincial legislatures in terms of section 80 or 122 of the Constitution, deciding on the constitutionality of any amendments to the Constitution. And here you can just note the case of UDM versus the President of the Republic of South Africa, where this was discussed. And then deciding that Parliament or the President has failed to fulfill a constitutional obligation, and certifying a provincial constitution in terms of section 144 of the Constitution. So those are matters that fall within the exclusive jurisdiction of the Constitutional Court. And then, colleagues, the Supreme Court of Appeal, it only hears appeals, colleagues. So you will never have a matter starting fresh or starting from the beginning in the Supreme Court of Appeal. It can never be a court of first instance. It's always appeals that it hears. And ordinarily, constitutional matters involving the development of the common law should first be taken to the Supreme Court of Appeal before they reach the Constitutional Court. And that is just because of the breadth of its jurisdiction and expertise in the common law. When the constitutional matter involved is one that turns on the direct application of the Constitution and does not involve the development of the common law or customary law, considerations of cost and time may make it more desirable that the appeal be brought directly from the High Court to the Constitutional Court, circumventing the SCA. So the SCA, colleagues, is still very relevant. There's been some debate about whether it's still relevant now that it is not the highest court in non-constitutional matters, but it still has relevance. And they're talking here specifically about it developing the common law. So where you do have to develop the common law in respect of constitutional issues, it's always good to still go through the SCA, so that it can have its say before proceeding to the Constitutional Court. But if there's no development of common law, then you can skip it and just go directly to the Constitutional Court. But again, the Constitutional Court would still have a discretion to say whether you needed to still go to the SCA or not. And then the SC and the High Court can hear constitutional matters and develop common law. Very important, colleagues. So actually, the first time that a lot of constitutional law matters are heard is in the High Court, and then it goes to appeal all the way up into the Constitutional Court. So they can actually hear constitutional matters. They're not excluded from doing that. They can also declare laws invalid, but this must be confirmed by the Constitutional Court to be effective, as I said earlier. And then moving on to institutions supporting constitutional democracy. So institutions have been established to strengthen democracy in the Republic, and these are the so-called Chapter 9 institutions, as they are found in Chapter 9 of the Constitution. That's why I refer to them as the Chapter 9 institutions, and they comprise the following: the Public Protector, the South African Human Rights Commission, the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, the Commission of Gender Equality, the Auditor General, the Electoral Commission. And the functions of these institutions, colleagues, is to check or monitor government, to ensure accountable government, and transforming South Africa into a society in which social justice prevails. But please do note, these institutions are non-judicial, so they have no power to review and set aside laws or conduct of the executive. They do, however, have the power to ensure that the executive branch remains ethical in the execution of its functions. So that is where their power actually lies. And some of their features, colleagues, they have to be independent. They are subject only to the Constitution and the law. They must always act impartially. They exercise power and perform their functions without fear, favor, or prejudice. Other organs of state, through legislative and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. No person or organ of state may interfere with the functioning of these institutions, and they are also accountable to the National Assembly. And colleagues, I'm only going to talk about two of them because I see the others were omitted from the study guide, but please just read through so you can understand what the other institutions are actually responsible for. So I'm going to discuss the Public Protector, and the Office of the Public Protector is regulated under sections 182 and 183 of the Constitution, but there's also a specific act that regulates the Public Protector, which is the Public Protector Act 23 of 1994. And some of their functions are also referred to in the Executive Members Ethics Act 82 of 1998. And the main functions, colleagues, in terms of the Constitution, there are other functions that are elaborated on in the Public Protector Act, but I'm just focusing on those referred to in the Constitution. The Public Protector is empowered to investigate complaints by citizens concerning administrative actions of the state, mostly by receiving complaints from aggrieved citizens against government officials or agencies, investigate them, where necessary, recommend or order corrective measures in order to remedy the grievances and issue reports. So their powers, colleagues, in terms of section 182 of the Constitution, these are the powers granted to the Public Protector. They can investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice, to report on that conduct and to take appropriate remedial action. And then we see that additional powers and functions are also prescribed by national legislation, and for this you can look at section 6 of the Public Protector Act, which outlines additional powers that the Public Protector actually has. Colleagues, one of the things that were mentioned, I don't know if it will come in the exam or not, but please just be aware of the binding nature of the remedial action of the Public Protector. So it has been confirmed in a number of cases that the remedial action of the Public Protector is binding unless it is challenged on review. And for this, you can have a look at EFF versus Speaker of the National Assembly, the 2016 case. It's also referred to as EFF 1 in your tutorial letter. And then we also know that the Public Protector is independent. meaning they had to exercise their functions independently. And then you can also have a look at these additional cases just in respect of the role, the powers, the limitations of the public protector. And then the IEC, Independent Electoral Commission, this is regulated under sections 190 and 191 of the Constitution. There's also an act called the Electoral Commission Act 51 of 1996. And the powers, colleagues, of the Electoral Commission are outlined in section 190, and these include managing elections of national, provincial, and municipal legislative bodies in accordance with national legislation, ensuring that those elections are free, fair, and declaring the results of those elections within a period that must be prescribed by national legislation, and that is as short as reasonably possible. You can also look at additional powers, colleagues, of the Independent Electoral Commission under Section 4 of the Act, the ECA Act, which has additional objects and functions outlined there. We also know that the Independent Electoral Commission, as its name reveals, is independent as well, so it cannot be influenced in any way by any sort of political interference. And case law, you can have a look at the Electoral Commission versus Minister of Cooperative Governance and Traditional Affairs Act. That is also included in your tutorial letter 102. Okay, colleagues, then coming to the last chapter. We've been going. Coming to the last chapter, chapter 8, dealing with multi-sphere government. So we see that there's an establishment of multi-sphere government in the Constitution. This is specifically and explicitly referred to. If you go to chapter 3 of the Constitution, you will see the discussion on multi-sphere government or cooperative government. And section 40, subsection 1 specifically provides that in the Republic, government is constituted as national, provincial, and local spheres of government, which are distinctive, interdependent, and interrelated. So to get an idea of this, we've got 3 levels. At the top level, we've got 1 national government. Then in the middle, we've got 9 provincial governments. And at the bottom, local government, we've got 257 municipalities. Please also just be aware that we've got the Intergovernmental Relations Framework Act, which basically regulates how these different spheres of government relate or communicate with each other. And then the guiding principles for multi-sphere or cooperative government, colleagues, is autonomy, meaning that specifically local government must have a final say, or it has discretion over how it conducts its affairs, but it's subject to national and provincial legislation as provided for in the Constitution. We also have the element of supervision, where senior governments supervise local government. So we see an unequal relationship there, where national and provincial government actually supervise local government. And then we also have cooperation, where local government cooperates with the other spheres just to ensure that there is service delivery. So, colleagues, South Africa can be termed as a quasi or quasi-federal integrated system. And what this means is that it's not a strict federal system where, like, for example, the United States of America, each state can basically just make full laws on how it regulates its state, and there's no concurrency or anything like that. Here it's a bit more flexible. There's still that deferral to national government. So the division of powers is based on the assumption that both levels will be involved in delivery of a particular service. There's a sharing of power within functional areas. There's no strict division. Some subject matter are allocated exclusively to one level of government, but most are concurrent or shared. So we see that concurrency, even though there are elements of a federal state, we still see that concurrency, especially between national and provincial government. And then here we just have a little table showing you the different levels of government and what is contained under executive and legislature there. Colleagues, very important to note, you won't see the judiciary here. So as I said before, the judiciary isn't divided in terms of the spheres of government. It is just independent on its own, basically exercising its functions impartially for all levels of government. There's no division of the judiciary into separate levels of government. So multi-sphere government only applies to division of executive and legislative powers. Excuse me. And then in terms of the division of legislative powers, colleagues, as I mentioned before, we've got Schedule 4 matters, and these are matters which national and provincial government exercise concurrent competence to legislate, meaning that national and provincial government have the equal right to actually make laws in respect of these matters, but national government will trump provincial government for purposes of enacting laws in the instances referred to in section 146. So please go and have a look at that. And then we've got Schedule 5 matters over which provincial governments exercise exclusive power to legislate. So these fall exclusively within the powers of the provincial legislatures, but the national legislature can actually intervene if it is necessary to achieve the objectives set out in section 44, subsection 2. So it's only in those instances when the national legislature can actually interfere with the law-making powers of the provinces in respect of Schedule 5 matters. And then we've got Schedule 4A and Schedule 5A. These are matters over which local government is authorized to enact bylaws. So local government can also play a role in enacting laws, but they are restricted to these matters listed in Schedule 4A and Schedule 5A. Any matter falling outside of that, they wouldn't have the authority to actually enact laws. And colleagues, I didn't put it on here, but you will see in the slides relating to multi-sphere government, any matter, colleagues, please be aware of this, any matter that doesn't fall under Schedule 4 or Schedule 5, Schedule 4A and Schedule 5A, any matter that doesn't fall neatly under any of those schedules, the national legislature would automatically have the right to enact laws on that specific matter. These are called residual powers. So if any matter is not specifically or explicitly listed in these schedules, then or any other provision of the Constitution, then the national legislature or national government would actually have the right to enact laws on that specific matter. And then the supervision of local government, colleagues. This is done in 4 different ways. They can regulate, well, this is in respect of national and provincial government. This is how they supervise local government. They do this by regulating local government, monitoring local government, supporting local government, or intervening in local government. And you can have a look at each of those sections just to understand how this works. I also did do a detailed explanation on this in Monday's tutorial. So if you refer to those slides, you'll also be able to just have an understanding of how this actually works in practice. And then you can also have a look at this case law. And this is in respect of the intervening supervision power that is related to local government. Oh, okay, colleagues. So that is chapters 1 to 8. I did my best to just cover as much as possible. But if there are any concepts that you are not understanding, I have elaborated on them more in the individual tutorial that was actually prepared in respect of that specific matter. Okay, moving on to the examples of IRAC, FIRAC, and ILAC. I don't know why this is not moving, so you actually can't see which slide we're on, but we're almost done. Okay, colleagues, so you can do a bit of research on this method of answering questions known as FIRAC. It's usually used in the legal discipline for when you need to give an analysis of a case, or if you need to answer problem type questions. So the first one is FIRAC. And this is basically, you use this mostly, colleagues, when, for example, there will be a question about discuss this case or analyze this case. That is when you would use FIRAC. It just gives you a nice structure of actually answering that question. So first you would go into discussing the facts, the facts of the specific case. So sorry, FIRAC. The first line there, it shows you what FIRAC stands for. So it's facts, issues, relevant law, analysis, and conclusion. So when you go into discussing it, first you would go into analyzing brief facts of the case. So you would say, in this case, so and so approached the court because of this and this and this and this. You just give a brief outline of the facts of the case. You don't go too in depth because it does tend to take a lot of time, and before you know it, you've spent too much time on facts and you haven't gotten to the gist of your answer. So just a brief summary of the facts of that specific case. Then you will identify the issues to be decided. What is the question here? For example, the doctrine of separation of powers and how it is applied in South Africa. That can be an issue. Or how does it apply in South Africa? Those are the issues that can be identified. Then you will refer to the relevant law applicable. For constitutional law, obviously, for all these cases, they will refer to provisions of the Constitution. So that is what you would refer to there. You can also refer to other cases that would be applicable. So when we talk about relevant law, we're talking about any law that would be applicable, whether it's legislation. Here it would mostly be the Constitution, and any other case law that is applicable. Then you would apply the law to the facts, and then you would conclude with your answer. You see there's a hand up. Andrea, your hand is up.
Yes, ma'am, sorry. Just to be clear, because I don't really, this is my first time dealing with it.
Mm-hmm.
So we have to state the facts of our cases briefly,
Mm-hmm.
then the issues,
Yeah.
and then elaborate. In
Yeah.
essence, that's what we have to do.
Yes, so you would elaborate, and then you would, there's always law that is applicable. Even in your judgment, you will see it. For example, they will refer to a specific section, section 172, section 89. So you would refer to those specific laws, then you would apply the law to the facts, and then you conclude, because that's how your judgments are also written. There's a set of facts, there are the applicable laws, there's the application of the law to the facts, and then there's a conclusion, which is basically the answer to the question or to the issue.
Okay, because I noticed when you say the facts state, is this just a summary of this? Because they mentioned facts twice in the bullet points. I'm not sure if I'm reading it correctly. So it says mention the facts of the case, but in another section it also says facts of the case. So it's like double, or am I not reading it correctly?
Where are you? Are you under FIRAC?
Yes, the first one, FIRAC.
Yes, so okay, so sorry, where we actually start with FIRAC is here. So here I was just giving you what FIRAC stands for, and then
Okay.
here I was telling you when you would use it, and then here so I talk about the brief facts of the case, identify the issues, refer to the relevant law, and then you apply the law to the facts.
Okay, so
Yeah.
for applying the relevant law to the facts, you'll say because this law agrees with these facts, this is why I chose it, in essence.
Yes, yes.
And in conclusion, this is why I think this judgment is correct.
Yes, 100%.
Oh, okay, thank you.
Yeah, 100%. Yeah, that is exactly it.
Okay.
Thanks, Andrea. Thanks for asking those questions as well, because yeah, it does get confusing sometimes, especially when you're discussing cases. So it's good to just have insight. But I mean, it's not like the lectures will actually strictly mark you on FIRAC. It's just basically to assist you in formulating your answer. So even if you don't follow this exact formula, as long as you can sort of follow a coherent or logical way of explaining your case or explaining your analysis, that would still suffice. It's not like if you do not strictly follow these steps, then you won't get your marks. So yeah, please, colleagues, this is just to assist you. It doesn't mean you need to cram this way of answering questions. I think as long as you are substantiating yourself adequately, you will get your marks.
Thank you.
All right.
Because I was a bit confused at first.
Yeah, no, it's just to guide you. It's just to assist you, because sometimes you're blank. You have all this information that you want to put down, but you don't know how you should actually phrase it. So this just helps you to formulate an answer that would be logical or coherent. That's what it helps you with.
Thank you. I feel like everyone's going to miss these lectures, ma'am. It was a real help.
Well, hopefully they can get the recordings, but yeah, please do share information where you can, guys. If one person is winning, then it's good for all of us to win. Okay, and then IRAC or ILAC, for me, this is not to say this is strictly how it is always applied, colleagues, but for me, how I used to apply it when I was studying is I would use ILAC if it's just a problem type question. And that is also what I will go through here in the, in the example. So ILAC or IRAC, colleagues, it's basically just a shorter version of FIRAC. You don't go too much into the facts, but it shows you how you answer a problem type question. So you would first identify the issues, and then you would refer to the relevant law. You would apply the law to the facts, and then you would conclude. So it's basically just a shorter version of FIRAC without going into facts, because when you're not analyzing a case in particular, it's not necessary to go into pages and pages and pages on facts. As I said, it takes long. So if your question is not really case specific, where they didn't ask you to really discuss a case, and you literally just want to apply sort of a method to your problem type questions, and this is how you would do it. Okay, so I've got an example that I made up here. It's just like a purely fictional example, guys. Please don't roast me or report me or anything like that. And also, you will see here that I've said issues, laws, apply, conclusion. You wouldn't write this when you are putting your answer. The lecturer will just see that this is the flow of how you're going. So you don't need to necessarily write issues, laws, apply, conclusion. No, your answer would just flow from these issues are in terms of the constitution, blah, 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 and therefore blah, blah, blah. So you don't need to divide it in this way. You just like, yeah, flow, if that makes sense. I hope I'm making sense with that. Okay, so this is just a little example that I came up with just in respect of the public protector and the binding nature of their remedial action. So I say President Kuvuki of South Africa decided to build a luxurious cinema at his home using public funds. This has been reported to the public protector, who has prepared a report indicating that the luxurious cinema was an improper use of funds, and the public protector has included remedial action in her report to the effect that President Kuvuki should repay the funds used. President Kuvuki doesn't believe that the remedial action is binding and doesn't repay the funds. Consider whether the remedial action by the public protector is binding on President Kuvuki and whether he has to repay the funds. Okay, so issues, colleagues. Already here you can pick up what the issue is. We're talking about the binding nature of remedial action. Because the president doesn't believe that remedial action is binding on him. So you can say the issues in these particular circumstances concern the powers of the public protector, and in particular whether the remedial action of the public protector is of a binding nature. So you've outlined your issues there already, and then you go into your laws or your rules. And here, as I mentioned, colleagues, you can refer to any specific act, any case law, or any other sources of law that would be applicable. It's not just limited to those. But for constitutional law, as we always say, you'd usually refer to provisions of the Constitution and case law. in terms of section 182, so I just went on to say, in terms of section 182(1) of the Constitution, the public protector has the power to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice, as well as to report on that conduct and take remedial action in respect of same. So you see, you are already linking it to the issue at hand by referring to the specific section. And then you can say, in a similar case of EFF versus Speaker of the National Assembly 2016, following alleged security upgrades to the president's homestead, the public protector investigated such upgrades and reported on and stipulated remedial action in respect of such upgrades. Despite such remedial action provided for by the public protector, the president did not implement same. The EFF then approached the court for an order that the remedial action was binding and that the failure of the president to comply with same was invalid. Furthermore, the National Assembly's resolution absolving the president from the compliance with the remedial action was invalid. In that case, the court held that remedial action has to be binding to be effective. So answering the question a little bit with your law or your rule, and that the president's conduct and the resolution of the National Assembly were invalid. So you've nicely set out your constitutional provisions, you've referred to your case that is relevant to the set of facts and that you can be able to apply, and then you go ahead and apply, colleagues. So here we can just say the public protector has the constitutional powers in terms of section 182 to take remedial action against President Kuvuki. The remedial action of the public protector is binding on President Kuvuki as held in the EFF case. So you can see there we're linking the laws and the rules to the issues we're applying. That's how you apply. You refer to the laws and the issues and you apply them to you have referred to your law or your rule and you apply them to the issue at hand. And then you conclude. So here we would basically just say, in answering the question, because that's what you need to do in your conclusion, you actually need to answer the question that has been put. And you'll say, President Kuvuki must comply with the remedial action of the public protector and pay back the money as the remedial action is binding on him. So you're just summarizing now how you've applied the law to the facts or to the issues, and you apply that to your question in answering your question. So yeah, colleagues, that is how you typically answer your long problem type questions. Identify the issues, refer to the laws or the rules, apply, and then conclude by answering the question. That's what you do in your conclusion. Some people get confused about what they need to say in their conclusion. In the conclusion, you are answering the question that has been put. After outlining all your laws, all your rules, after applying, then you answer the question at hand. So yeah, that is my story on how you can answer your long problem type questions. I didn't do an example of FIRAC because yeah, it would have been too long. I just did this one so that you can know how to answer your problem type questions. And yeah, that is that.